Ladies and gentlemen, welcome back to the Indie Zone podcast. This is Kathy. On the 31st of December 2024, the state of Idaho filed their objections to the defendant's motion to compel ICR, that's Idaho Criminal Rule 16b7 material and for sanctions. This document just appeared on the docket about 2 days ago, and it is responding to a very terse defense filing where the defense was arguing that Mr. Koberger's rights were violated because the state allegedly did not comply with Judge Hippler's October 9th, 2024 order directing them to make initial expert disclosures on or before December 18th, 2024. The state has a completely opposite view here. And I do recommend that you look at this document, possibly print it. It has a lot of new information not previously known to the public and some good legal arguments regarding what the law is on expert disclosures. And with this regard, I would like to direct your attention to page 4 of the filing. And it states here that ICR Rule 16J imposes a continuing duty to supplement the response to discovery, which the state has said that they have been continuously disclosing information, including potential witnesses, to the defense since the beginning of the case. It states here that the first discovery response was filed in January 2023, and they have continuously complied with their obligation to supplement a response if it is later determined a supplementation is required. With respect to expert disclosures, for example, what a potential expert that the defense might have called in January of 2023 may be a completely different expert today, 2 years later after an ongoing investigation as more facts became aware. Now, on the next page, which is 5, the Idaho Supreme Court in Koch, the state discusses here, addressed the scope of ICR 16b7 disclosures and looked at the Federal Rule of Criminal Procedure, and the Idaho Supreme Court in this case that's really central to the state's argument found that there's different standards. Federal law requires a lot more than what state law does relative to these expert disclosures, with the bottom line being that what the state actually disclosed is proper. That is what their argument is, because it gives them the option of providing a written summary or an expert report. They really drive that point home, that an expert report is not really necessary. A written summary will comply with this rule, is what they appear to be arguing. Then they go on, if you follow along with me, on pages 6 and then beyond that, they begin to disclose the types of expert witnesses that they have already disclosed to the defense. For example, S as in Sam 1 and S as in Sam 6. These are filings that were under seal of December 18th. They say here that these are the disclosed expert opinions regarding the toxicology reports for the 4 children that were so brutally taken on November 13th, 2022 at 1122 King Road. Further on, they give disclosures describing Kathy Mabet was disclosed as a potential expert. She, of course, is the Latah County coroner. They discuss the automotive experts that worked on identification of suspect vehicle 1 via video and forensic information, photographs, and other materials, things along that line. So we're learning here for the first time what some of these experts are expected to testify to at trial. Finally, the state is asking that if they somehow neglected to comply with the order, to give them an opportunity and they will go amend as required. And they also are asking that Judge Hippler make a ruling without a hearing on this matter. This will now conclude this episode of the Indie Zone. Thank you for joining us here today.